Hi, it's Mike from MrBounceback.com. Now, I'm still taking a huge number of calls to my Bounce Back Loan helpline, and with many callers asking similar questions, today I've assembled an expert panel for a discussion on dealing with some topics that hundreds of callers have expressed worries and concerns about, relating to the Bounce Back loans and the businesses. I've managed to get together a panel for this fireside chat that includes solicitors, business advisors, and even a business mentor, who are all happy to take part and were generous enough to give up their time to speak to me. If when listening to our discussion you can relate to any of the topics which may be causing you sleepless nights, anxiety, or a sick feeling in your stomach, please give my helpline a call. It's always me you speak to, and I'm available 12 hours a day, 7 days a week. My guests today have also told me, well, I blatantly and unashamedly asked them to agree, that if you want me to pass your contact details over to any of them for a completely free of charge and confidential chat on any of the topics discussed, just so you know what your legal options are moving forward, then they're more than happy for me to do that. I know a lot of you are going to be listening to this fireside chat alone and have deep-rooted fears, worries and concerns about a bounce back loan that you can never repay, and have no one to talk to about those concerns. If that is the case, then call me and let's chat. It'll be like a weight lifted off your shoulders if you do call, and you'll discover just what your options are moving forward. And there are more options available than you may have realised. So the first question I asked, I directed it over at the business mentor, and it was about taking the insolvency route when you've got a bounce back loan owing, because the number of calls I'm getting on this topic is off the scale, and people just don't know the process, what they should be doing, the pitfalls, this, that and the other. So that is what I put to the business mentor, and this is what he said.
Okay, so Mike, there are two types of bounce back loans. One for the sole trader or partnership, and there's one for the company.
Okay.
What you should do in both aspects is maybe approach your accountant, ask him for advice, tell him all the debts that you have, tell him all the problems that you've got and all the issues that you have. And then he should be able to guide you in which direction to go to. You can also approach, if it's a company bounce back loan, a liquidator, talk it through with them.
So a liquidator, let's just describe, some people know that as an insolvency practitioner.
Absolutely, yes.
So we have to, the person sat at home who's got a limited company has no other option but to take the liquidation route. We'll have to find an insolvency practitioner. Now, I've been told some horrible stories about these. Some people are having cold calls, all kinds of nonsense. If I approach an insolvency practitioner, it's going to cost me money.
To be honest with you, the advice should be absolutely free.
Initially,
yes. And you should ask all the right questions, right? Yeah. You should tell them that this is what I had. This is how the money was used. The one thing that you got to remember, insolvency practitioners, once they've got you signed up, they are going to look at the conduct of your affairs in the company, because you are responsible for whatever happened in the company. And if you've done wrongdoing, if you've taken money out, if you've got a director's loan account, if you've used the money wrong, they can come after you. If you've got an asset, and look, I'm not trying to frighten anybody, right? But because I have spoken to so many people who have done liquidations, they've been promised a rosy garden.
I'm hearing the same side day in, day out.
Yeah.
A lot of people have been either rushed into taking the insolvency route, they've not been given a clear route they'll have to take.
This is what they're going to do. They're going to look at your last 3 years' accounts. Then they're going to do the investigation with the bank statements from the last company accounts to now. From that, they will be able to work out what's wrong. It depends on what his findings are.
Okay, so that's a basic insight into the liquidation route. And as such, if you are thinking about taking that route, what you need to do is be seeking out an insolvency practitioner. And for those listening, I do have a list of insolvency practitioners. So if you want the details, give me a bell on the helpline and I'll pass them on to you. So with that question out of the way, I asked one of my legal professionals to give me some examples of alleged wrongdoing that could be uncovered when you take the liquidation route, and how people can go about defending themselves when there are mitigating circumstances.
Yeah, so what we found with clients is the wrongdoings are usually they've overinstated their turnover.
I call that over-egging turnover. So if that's somebody, because this is an important point I'll just jump in on, not everybody could estimate their turnover,
Yeah.
right? You could only estimate your turnover if you were set up in 2019
Yeah.
onwards. So everybody back from that had to use the 25% of their
accounts,
official, yeah.
So we've got, again, overinstating their turnover to obtain a bounce back loan more than they should have done.
Mm-hmm.
We've got that they haven't used the bounce back loan money for the benefit of the business. And then we've also got that some people have taken out more than one bounce back loan on the company.
Mm-hmm.
There's loads of different situations that we've seen. We've seen people who've taken out a bounce back loan. As soon as they've signed for the bounce back loan, obtained the money, they've attempted to dissolve the company, and this has been successful as well.
Yeah.
We're seeing quite a lot of them as well. But mainly, I think the Insolvency Service, they're trying to go after the directors who they believe cannot provide evidence that they've used the bounce back loan for the benefit of the business.
Right.
This can be, I mean, even going out for a meal. Let's say you've taken your accountant out for a meal to get more clients from him. I mean, that is for the benefit of the business, but the way the Insolvency Service are looking at it, when they look at the bank statement, it just looks like you've gone to a restaurant and spent money there. So this can be argued if something is for the benefit of the business. It's subjective, and we can help directors to go through how they've used the bounce back loan, the invoices that they've got to hand, and if they don't, then we can go back to the Insolvency Service, request a bank analysis that the liquidator would have done.
Mm-hmm.
This is basically like an Excel spreadsheet where they categorize the money going in, the money going out, any money that's gone to the director or to connected parties. And we can sit through with the director and go through what they have actually spent the money on and give a proper explanation to the Insolvency Service and justify as to why they were able to do what they've done. And that can hopefully get them off disqualification or reduce.
Yeah, but I have seen it. I have seen, like I say, on the website, there's so many. There seems to be no rhyme or reason to the amount of ban or disqualification somebody's going to get. It's like, I call it a postcode lottery. It's like somebody in one part of the country will get a 12-year ban and somebody in the other part of the country will get a 6-year ban for the same sort of offence. Have you discovered something like that as well?
Yeah, we found that there's a lot of discrepancies between the investigators as well. They don't seem to have like a scale on where they're assessing each different director or what they've done wrong. It seems to be some directors are harsher than others, some don't listen to the evidence that you put in that's quite clear in front of them. There is a discrepancy, and it makes me feel that there's not like a scale, or they're not judging it based on previous cases. They say that they judge it on a case-to-case basis, but so many of these cases are similar, and the disqualifications that everyone's receiving, they differ. People at the time, about a year ago, they were scared, and if they thought just signing the undertaking would finish this whole process, I mean, liquidation is a long process as it is, they thought that if they just signed the 10-year disqualification, they don't argue it, then that's easier for them. But that has kind of set a precedent now. So all these people that have just signed for the 10 years, it's set a precedent where if someone does now want to argue their disqualification, it's already starting at 10 years now, because other people have just accepted it.
So many people have phoned me up at that stage where they say, Mike, I've just signed the undertaking. No, the undertaking is actually when... Explain what the undertaking is. How do I... So I've gone through the insolvency process. Now, behind the scenes, the insolvency practitioner has to inform the Insolvency Service of any wrongdoing. They then decide your punishment, for want of a better term, and then you get a sort of final chance of throwing yourself at the mercy by explaining things. Yes, so just give us a bit of a talk about that.
I think when it comes to a certain point in the disqualification process, the director's left with a situation is in that, does he give an undertaking, or does he try and contest or fight the alleged unfitness that's being made against him by the Insolvency Service? Sometimes you'll get a director who thinks, I need to get on with my life. I'm not going to be a director again. I'll just take what's given to me and I'll sign it. Often they haven't taken any legal advice, any advice from anybody. and that's also a risky situation to be in if you don't take advice. But they've made a decision, and they'll offer an undertaking, and the undertaking generally is the insolvency service saying, we will disqualify you for 5 years, 10 years, 12 years, and the director just agrees it.
Yep.
And at that point, they are disqualified for that period of time, and they can't be a director of a company for that period of time. And it will be registered on the company's website as well.
Yeah.
So it's publicly available information. So if somebody looked at it at a certain point in the future, it will pop up that person is a disqualified director. The best situation, if a director does receive a letter from the insolvency service asking them to give an undertaking, is to go and get some legal advice.
Yeah.
That is so important that a director does that. They need to know what their options are. They need to know whether there's a good chance or there's a possibility of defending the alleged unfitness that they've been accused of by the insolvency service. So sometimes there are situations where it's not worth challenging it. Sometimes it can be challenged to an extent where the length of time that the insolvency service wants to disqualify them for can be reduced. Not always, sometimes it can, but it's definitely worth taking advice.
Yeah, because I've chatted to people who have been told they were going to get disqualification. They've then taken on legal advice, got a solicitor involved. That solicitor has then looked at the case with fresh eyes and says, I don't know, for example, that person was vulnerable and the insolvency service has not been made aware of this. And the solicitor will then write to the insolvency service and put an impassioned plea on their behalf, if you like. There's some mitigating circumstances. I have seen the insolvency service and the Secretary of State saying, well, just quashing it. Did you see much of that?
I'm seeing more and more of that. It's,
Right.
COVID was a stressful time for most people, but being in business and with the various lockdowns that happened, businesses had to shut down, had to restrict the number of people coming to their establishments. There were so many restrictions on businesses, especially in the hospitality sector as well. I mean, it changed the hospitality sector overnight. It destroyed it pretty much. And directors, if they weren't already suffering stress and anxiety, they certainly, when all this happened, their stress and anxiety increased tenfold, 20-fold. How are they going to pay the bills? How are they going to make money, pay staff, retain staff? Even when there was a time they were aware the lockdown would be lifted and they come out of this on the other end, would they be in a position to pick it up where they left off and just carry on? Especially if the staff have already left. So the vulnerability aspect and the mental health issues that directors have clearly and legitimately faced are important factors. And the insolvency service, the Secretary of State, needs to be aware of it. I mean, it's often good where if there's some kind of medical evidence as well, you've been to see a doctor's had a chat with you, you may have been referred on to somebody. It's as much evidence as you can get together that can show that you've been suffering. And it may not just be, it could have affected your whole family, because these things generally do. And it's dealing with the stresses of your wife and your kids and how am I going to make money in the business? I've got to pay the mortgage at home. I've got to feed the kids. It all adds up. It all adds up, and it increases that stress and anxiety on the director.
Another question I asked, if you consult a solicitor, are you going to be looked at like you've got something to hide when you're defending yourself, or letting the insolvency service be aware of any mitigating circumstances? And this is what he told me.
I think what I'd say first, just because you go and get some legal advice from a solicitor, and even if you decide to instruct that solicitor to then write to the liquidator on your behalf, it doesn't mean that you've got something to hide. Often the solicitors and liquidators, they talk the same language, they understand what they're saying. With no disrespect to the directors, they don't always understand what's being asked of them. And all it requires, in most cases, is for that director to send the papers to the legal person. They can have a look at it, see what's gone on, and then put that very carefully and concisely in a letter, in correspondence to the liquidator, and explaining to the liquidator, answering his or her concerns. So that's an important step.
Can I just say that with an insolvent, people need to understand this. You are actually paying for the services of the insolvency practitioner, but they're not working for you. They're working for the creditors. Is that correct? And that's what a lot of people can't understand.
That is correct. So initially, when a director goes to a liquidator for help, they will pay for the liquidator's fees. It's often seen that the liquidator's got two hats. Initially, the liquidator's there to help you effectively close the business down properly, legally, deal with any creditors that are owed, any outstanding monies. But at that point, you've done your bit with the liquidator. Yeah. The liquidator then effectively takes over and examines the books and records of the company, looks at what's owing to creditors, and also goes through all the bank statements to see what you as a director have been doing. If you've paid somebody when you shouldn't have paid somebody, you've taken too much money out yourself, you've transferred maybe an asset or money to a family member or a third party, and there's no paper trail of it in the accounts. The liquidator will come to you to ask those questions. And yes, they were your best friend right at the beginning, but if they're any good, they'll continue to be your best friend, or just friendly and try and help you through the situation.
Yeah.
But at that point, the liquidator must have regard to the creditors of the company.
Yeah.
That's he or she is acting for. So at that point, a director should get their own legal advice, especially if
so even though I've taken on an insolvency practitioner and they're asking me all kinds of questions, I should have a solicitor there to answer these questions if there's some ambiguity.
Yeah, not always, but I think it's important, especially if you don't understand what's being asked of you, because often the answers that you give, it may come back to bite you. If you've said too much or you didn't say it in the right way. Obviously, you always need to be honest. Honesty is key. But there's a way of putting things across as well, especially in a way that needs to be, you would like it to be understood, your situation, why you did it, what the reasons were for doing that. You need to come up with some reasonable answers, and usually a solicitor can help, or a legal advice can help in that situation.
Okay. I get a lot of phone calls from people telling me they've had a letter out the blue. They'll be paying off the bounce back loan quite happily, but they'll get a letter out the blue from their lender demanding all manner of extra answers to questions. They call it an account review or a safeguarding review. Basically, the bank is sticking their nose in saying, how did you reach your turnover figure, or how did you spend the funds, or questions like that. Can you help with somebody who's in that position, and why are they asking these questions?
This is quite common, and the banks will often send a letter out during this account review process to the director and say, look, what's this all about? Please explain how you estimated this turnover figure.
Yeah.
And we can help in this situation in trying to explain very carefully why the director chose that turnover when he inputted the data into the application form. You need to be quite careful when you do it. And
I'm of the mind that they already know the answers to the questions they've just asked and just want to hear it from the business owner's mouth. Is it some sort of phishing or a trap exercise? Or could it be just a case of you can help them say, look, I know you think I've over-egged my turnover or I spent the funds on this, that and the other, but here is a factual, honest breakdown of how I arrived at these figures.
I think it's probably more of a phishing exercise. I think they just send these letters out as a matter of course to see which of the more
high risk.
Yeah, so. the challengeable applications for bounce back loans and the reason why people took them out in the first place.
Because people are getting these letters 2 or 3 years after they actually got the bounce back loan. Yeah.
I think, the banks, they're not being culpable for how easy it was for the directors to obtain the bounce back loan. There was no due diligence from the banks, and they're now being scrutinised, and obviously the directors are being scrutinised. I think the government is also putting a lot of pressure on the banks as well, which is why now they're kind of backtracking and trying to do all this due diligence now.
But I think, to be honest with you, right, I think, the government should have a lot of the blame because they directed the banks. I mean, their questionnaire was very short to apply for the bounce back loan. And they told the banks to pay out the money because they were paying out within 24 hours, 48 hours.
Yeah, there were no checks or balances at any stage of that initial process. And it's only now, a few years later, they've had a chance to look back and see what's gone on. This effectively free money they gave out. And now they're all jumping up and down trying to recover the money which they freely gave out in the first place. When initially they should have had these checks and balances in place, but they rushed it through so quickly. And poor directors, they're in a situation where they had no one to speak to. They couldn't get hold of an accountant because the accountants were closed. Everyone's working from home. There were no professional advisors to speak to. They had to make a decision with very little written guidance or any kind of guidance at all.
And exactly, because they actually changed the law, didn't they? The
Yes.
Consumer Credit Act, yeah? And then you had to sign to say you knew that you didn't have any rights.
Exactly.
And they've jiggled something about.
Yeah.
And then you couldn't get hold of a legal person to explain it all to you at the time. And you had to, it's absolutely crazy.
Yeah.
And now, unfortunately, banks are asking for these account reviews and quizzing people, and there's people wanting to take the insolvency route, but they don't know. All they hear is the headlines in the newspapers, how such and such bought a sports car and is now being... I'm also finding that a lot of people are in sort of a limbo land, whereby the company has... Because there was a loophole right at the start of the scheme, wasn't there, whereby you could apply for a bounce back loan, put it in your back pocket, get the company struck off, and then Bob's your uncle. But now they've changed the law and they're going after people and rightly jailing people who have blagged the scheme. But there's a lot of people in sort of a limbo land now where they haven't submitted something to Companies House and there's a strike-off has gone in, but it's been blocked. Now, I asked the Department of Trade about this. But basically they said, Mike, if we blocked somebody's strike-off, we're going to keep on blocking it because it bounces back every 6 months or so. And they've said the only way we're going to unblock it and let a strike off or a dissolution, as they're also called, go through, is if the person repays the bounce back loan in full, or if they've been classed as vulnerable by a lender and a special arrangement has been made with the lender. Is that something? Because I'm feeling, well, I know there's a lot of people in that situation now. Is that something from a legal profession you can help them with? They're in this limbo land, and because I think somebody's going to come chasing after them sooner or later once they've...
It's very easy for a director to strike off a company.
Yeah.
Often you pay your £10 and you send the application in, and it's done very quickly. It's processed.
Yeah.
However, they're looking at these more and more. They're scrutinising the applications more and more, especially when there's bounce back loans.
Well, it instantly gets blocked. They've
told
me it'll
get
instantly
blocked.
gets blocked.
Yeah, it gets pulled up straight away.
Yeah.
And that's when they can't use that route anymore and that debt just won't go away until it's dealt with.
Mm-hmm.
And that's where we can help. And either try and negotiate with the insolvent service or the liquidator. But yeah, don't leave it too late. you should take legal advice.
Because you're
Straight
still a
away.
live company, even though it's
and it will continue to be live, and that debt will continue to be there. So it needs to be dealt with.
Just to let you know, on the strike-off thing that we're talking about, you will find that if the company owes HMRC money or the banks, and these days even gas and electric companies are now going on because they put alerts on the company, so they will know when you're trying to strike it off, right? But if it's the bank and HMRC, it's very unlikely you'll get it struck off unless there's been a blip and they've missed it completely, right? Which does happen.
There was one in November 2022, I think. There was about a week or a month whereby a batch of them managed to get struck. Because they changed the laws now to block it. And
That's it.
They can now go after people who did take that strike-off route. So if you've read online, that's an easy way to get you. Do not attempt to try that because they'll come after you with a big stick.
And the other thing is, right, a lot of people, right, they don't realise that when you do a DSO1, because that's the form that you have to do, right, for the strike-off, you're supposed to send communication to all your creditors that you're closing the company and a statement of affairs accounts, right, but a lot of people don't do it and they still get struck off. So there's something wrong with the way things are done. And the other thing is, right, you find that if you try and strike off the company, if you got a bounce back loan with the bank, company bank, right, they will close your account as soon as you do the strike off. Because also you got to remember that the bank has paid out the 50,000 or whatever it is, right, for the bounce back. They can recover that money from the government once they close your account. And it goes into collections.
Right.
Well, we've seen that with the bank now. I believe it's Barclays. They've started to issue winding up petitions to wind up companies.
Yeah, I've covered about 120 of these on the website.
And once the notification goes in the London Gazette that potentially the company's being wound up, the banks will freeze the bank account as well, which means that all your suppliers, they will have notification as well that potentially you're being wound up, and they'll stop supplying to you. That income will stop coming in. And you'll have to obviously deal with the winding up proceedings.
So if you're a limited company limited company director out there, and you've just been ignoring the bank, there's a good chance in some instances they'll force you into.
The only bank that we know of at the moment, right, who's been doing the winding up orders is Barclays.
Exactly.
This is happening more and more, and also they're also instructing. Obviously, Barclays will instruct an insolvency practitioner, and they're under instructions to instruct a solicitor to go aggressively after the money as well. So that's happening a lot. So you need to make sure that you don't get to the stage where you're getting a winding up order issued against you, because more than likely the insolvency practitioner will be aggressive. And the other
is that when they can do the compensation order?
That will come as well, right? Look, first of all, they're going to try and recover them, because when the solicitor is going after the money from the director, the case is normally open. It's really when the case has been closed and no money has been recovered or no settlements have been done, that's when insolvency service, especially if they've disqualified the director, will go after a compensation order. Would I be right in saying that?
Yeah.
So that's what happens. And also, just the other thing that I've got to tell you is, right, the banks, when they close your bounce back loan account, right? So either when you put a DSO1 or if you file dormant accounts, that seems to be a trigger point. That's what I've noticed.
So if there's any directors out there
who are doing dormant accounts, right?
Talk us through this, because this is important.
A lot of accountants, they have maybe not informed their clients that if they've taken out a bounce back loan, they should obviously not be filing dormant accounts. Dormant accounts means that your company is not trading. But if you've signed the bounce back loan, you've told them that you are in essence trading and that you've got an estimated turnover, or this is your turnover, and you've received money from the bank, so you shouldn't be filing dormant accounts. And usually when the bank finds out that you have filed dormant accounts,
which is quite easy for them to do.
Yeah, it's public knowledge. It's on Companies House. they will potentially issue winding up proceedings against the company.
Or they'll just close the. The first thing they'll do is they'll close the bank account, so they can go to the government and get their money. And then obviously you've got then you really have to act on how to deal with the company. So it's very, as soon as your account is closed, you should really think about closing the company or how you're going to deal with it, right? So unless you can afford to pay the whole money.
Okay. If you can afford to repay in full, is that the end of the matter?
Well, to be honest with you, if that's the case, yes, it would be the end of the matter. And look, as long as you pay HMRC and the bank, because they're the first two creditors that get paid in insolvency. Everybody else comes last, if you know what I mean.
So there's another point. If it does get to that winding up stage, then again, don't sit back and let it happen. Go and take some advice, because you can try and delay that, or try and enter into negotiations to try and avoid the worst thing happening, that company being wound up, and there's more costs involved, and they will go after you aggressively. So it's important at that point, if there is a threat of the court being involved, some court action, it needs to be dealt with quickly. The solicitor, legal advisor can get in contact, correspond with the bank and their lawyers, and try and get this thing, if not delayed. Well, the delay might help because it could potentially open doors to negotiation. And if that happens, then all the better. We could try and avoid the worst case scenario, which is being wound up.
All right, well, can I thank you all for taking part? I quite enjoyed this. Can we do it again? Would you be up for it?
Oh,
yes.
Because if somebody sat at home, because the problem we've got is a lot of people are going to be listening to this at home, on their own, in the middle of the night, panicking and not knowing which way to turn. If you're in that predicament, you need a professional to talk to with any aspect of your bounce back loan. Give my helpline a bell. The number's on the website. I'll happily chat to you. I can point you in the right direction. And if you've got any questions you want to ask the team, can we expand the team? I fancy
Do you know something? Look, I know a lot of professionals, right? And if we can get maybe a liquidator on the table, let's do that next time.
Fantastic. And if anybody's got any questions, give me a bell. We'll have a chat, and I can put the questions to you. But I can certainly put anybody who's sat there panicking at home on their own, dead of night, worried about this bounce back loan. I can point you in the right direction. So give my helpline a chat. And thank you again.
Thank you.
Thank you.
Thank you.
Thank you.